Good afternoon, everyone. I'm Jam from FMA and the Ateneo de Manila University. Allow me to give you a brief discussion of how business organizations, can respect and uphold the right to privacy and freedom of expression in the digital environment. Our discussion will proceed in this manner. We're going to define and establish the legal basis of these particular rights, and then talk about the rationale or why we need to uphold and respect these rights apart from the obvious reason of there being laws requiring us to do so. And then finally, at the latter part, we're going to talk a bit about how we can actually fulfill this obligation of respecting and upholding these two particular rights in the business setting, and more specifically in the digital environment. So let's talk about the definition and legal basis of these rights. First, the right to privacy. When we talk about the right to privacy, different people will actually give us different definitions of what the right to privacy is. But if we take them all together, we will most likely get a sense that it represents this space, this sphere where we as individuals are allowed to be ourselves. We are allowed to be alone, to do things, to say things, to think about things away from the prying eyes of others, away from being observed by others, away from being not being influenced by others. So having this space that represents our right to privacy. And when we're talking about the right to privacy, we cannot avoid but also talk about the so-called different aspects of privacy. It's important to talk about them because if we look at these different laws we have right now, we have specific laws that cater to specific aspects of privacy. So they are, in that sense, different. So it pays to understand what are these different aspects to begin with. We have communication privacy, which essentially means protection afforded or given to all modes of communication we engage in, whether it's writing an email or snail mail, or whether it's talking with another individual. If we want all these things protected so that other people aren't able to read our letters, aren't able to hear what we're saying, this is communication privacy. If we're talking about territorial privacy, this is the physical space. If we want a particular region, particular area, particular facility uh, wherein we are able to be, where we are able to do things uh, without the interference, without the involvement of other people, then that's territorial privacy. That's why we have laws against trespassing. That's why we have laws like violation of one's domicile. That's why we have laws governing the use of surveillance cameras, and so on and so forth. And then we have bodily privacy, which talks about our physical bodies, why we are able to assert that we cannot just be subjected to some sort of test, blood test, urine test. It's also why we're able to assert that we cannot just be subjected to physical inspections, like when we enter a mall. If we don't want to be inspected by the guard, for instance, and then just decide to leave, that's essentially us exercising our right to bodily privacy. And then finally, you have data privacy, which is essentially our right to assert some sense of control over our personal information so that we can determine who gets to collect our personal data, what they can use it for, where they can use it or process it, and how they can do that, whether it's manual, whether it's automated, and all these things. The way we are able to exercise some control over these things, that's our right to data privacy. So for the legal basis of the right to privacy, we have numerous legal instruments at this point in time. On top of that list will remain the Universal Declaration of Human Rights, specifically Article 12. So although this is not strictly a law, it is perhaps the most famous because all these other actual laws tend to refer to this particular document. But when we're talking about actually enforceable obligations with respect to the right to privacy, we're going to have to start with the ICCPR, or the International Convention on Civil and Political Rights, which is a treaty. As a treaty, it is a law that once a country signs it, it has an obligation to fulfill its obligations in that particular treaty, such as respecting a person's right to privacy. Locally, or in the domestic scene, we have also laws that uphold the right to privacy. And on top of that list, of course, is our 1987 Constitution. There are several provisions there that talks about the right to privacy, even if only one of those provisions actually mentions the word privacy. That's privacy of communications. The other provisions, although they don't explicitly mention the term privacy, you get a sense that they are actually referring to the right to privacy simply because of the protections they provide to every individual. For instance, protection of an individual against unreasonable searches and seizures. So we were talking earlier about territorial privacy, about bodily privacy. These are manifested in this particular right against unreasonable searches and seizures. And then we have a more recent law like the Telecommunications Act. It's important in the sense that it imposes obligations on employers and employees to protect personal information they are handling while they are in a work from home arrangement. And then finally, we have the Data Privacy Act 2012, which the entire law itself is about data privacy, but more importantly, it has this list of specific rights. So it's not just right to data privacy, but specific rights manifesting the right to data privacy that each individual has and can assert against any other individual, against an organization collecting and handling their personal data. I'll just give two examples. The right to be informed, for instance. That means if your information is being collected by an organization, that organization has an obligation to tell you why it is collecting your information, with whom it plans to share that information, how long it intends to keep that information, and all these other details. That's what the right to be informed means. The right to damages, on the other hand, means that if an organization uses your information and then as a result, you suffer some type of harm or incur damages, then you have the right to claim damages from that organization. You can file a complaint with that organization. You can file a complaint with the National Privacy Commission. You can file a case with the courts. And as a result of these cases, you may be awarded indemnity or damages. So that's the right to damages. So let's set aside the right to privacy for a moment and take a look at freedom of expression. Freedom of expression, compared to the right to privacy, I think most people are able to understand it almost immediately, because it is essentially a person's ability to express himself or herself. That's what freedom of expression means. And when we say it is composed of two modes, content and form, it simply means we can express what we want and in any manner that we want to. So if we want to express our condemnation of what the government is doing, and we want to do it by protesting in the streets, that's a person exercising his or her right to freedom of expression. If you want to express your happiness and then you want to do it by dancing in public, that's another way of exercising this particular right. So, what's another thing rather, that's important to remember is that freedom of expression rather does not only encompass or cover those those expressions that are accepted or are popular uh, among the majority of the people or in society rather. So you can still express yourself in a manner that most people most people would frown upon, but as long as you don't cross that boundary or yeah, that boundary that the law sets, uh, you are safe to carry out that particular act, that particular activity of expressing yourself. Uh, we don't always have to do things in a way that most people find convenient, find acceptable, uh, or to their liking, or in accordance with their tastes. So that's another thing that we should remember about freedom of expression. And similar to the right to privacy, we will also find freedom of expression in numerous legal instruments, both international or local. And as you can see, they share pretty much the same set of policies. Of course, there are still other policies out there, but this is just a sampling of those policies. I included Telecommunicating Act there because essentially the law says that any right that we are able to exercise as employees while working at the office, we should be able to exercise while working away from the office, or like when we're working from home. Now, why do we need to uphold this right? So we'll mention later on that it's because of there being laws requiring us to do so, but there are two other things that should motivate us to actually uphold and respect human rights in general, and these two rights in particular. First, it's because by upholding and respecting people's rights, as organizations, as business entities, we are able to gain the trust of people, whether it's our employees or whether it's our customers, clients. We're able to uh, gain their trust so that they will have confidence in our products and in our services. What happened in Facebook 2 years ago is a classic example of a business losing the trust of its customers, in its case, its users, and as a result, it lost a lot of value uh, because of this incident wherein it was caught allowing other companies using the personal data of its users. So we should uh, see that as a clear reason why we need to uphold rights. Because if all these people think that we're not doing that and they lose confidence in our products, in our services, then we could actually lose our business. Second example, is this local company wherein they were seen and widely reported to have violently dispersed uh, the strike being conducted by their employees. So when you carry out a strike, you're actually exercising several rights there all at the same time. One of them, of course, is the right to freedom of expression. And in this particular case, when the company was reported as not respecting its employees' right to freedom of expression, among other things, many individuals actually called for the boycotting of their products. So clearly, every business, every company has a reason to uphold human rights simply because of these examples I've shown you. Another is that we are able to entice more investments, attract money, actually, by upholding human rights. So, if in the first example it was about not losing money as a result of not upholding human rights, in this case, it's actually getting more investments, getting more money as a result of upholding human rights. The EU is known for entering into agreements with countries that agree to its condition that they are supposed to uphold human rights in their respective jurisdictions. So if a country, a particular government, is unable to or is unwilling actually to agree to that particular condition, then it loses this potential investment from the EU. And as a result, the businesses in that particular country also see that, or should also see that, as a lost opportunity. So this is another reason for wanting to uphold human rights. And then the third, which is what I mentioned earlier, is actually because it is required by law and by regulations. There are all these different laws saying that protect the right to privacy, uphold the right to privacy, or all these other human rights like freedom of expression. Otherwise, you will suffer penalties. So, data privacy these days, that's a very common source of penalties, or data privacy violations rather. That's a very common source of cause for companies suffering penalties, because many companies, especially in the EU, are found to be violating their data protection law there, which is the GDPR, or General Data Protection Regulation, and they're being required to pay all these fines. But it's not just fines. For instance, in over here in the Philippines, our data privacy law actually imposes criminal penalties. So you could actually get sent to prison and still required to pay a fine if you are caught violating the data protection law and committing one of the offenses specified in the law. So in this particular example, three companies who have money lending apps as their product and money lending as their services were charged, or at least the National Privacy Commission recommended the filing of charges against them after receiving thousands of complaints involving these money lending companies. And then in 2017, supposedly came the first time that a person was actually convicted for violating the Data Privacy Act. So, uh, apart from the monetary fines, imprisonment is a pretty good motivation also for companies, specifically the individuals that make up these companies, both managements and employees, to actually comply with the law and in turn uphold human rights in their respective business settings. Now let's talk about the duties and responsibilities. So we know what the right to privacy is, what freedom of expression is. We've seen why it's important to uphold them, apart from the fact that we are required to uphold them. So how exactly can we do this? Translate this into actions in our respective companies or organizations. First, we can do so by making sure that respect for these rights are actually manifested in our day-to-day operations and in all these different systems we have in place in our respective organizations. Uh, it's only by embedding this in the system that we have a great chance of actually being able to consistently uphold these rights, because without these policies in place, we will most likely have to rely on officers or individuals uh, really caring for these rights, such that even without any policy requiring them to, they make it a point that uh, the rights of whether their employees or their customers or their clients are protected as the company or the business carries out its operations. And another way we can do things is by preventing or mitigating whatever adverse impact our operations has on the exercise of these particular rights. So since we are talking about the digital environment, let's mention some specific examples. For instance, with the freedom of expression, we have the obligation to make sure that our employees are able to exercise this particular right uh, while working for the company. We should be aware, as a company, as an organization, we should be aware of what line we should not cross in terms of trying to regulate the behavior of our employees, of our personnel. Uh, One example I would give would be situations wherein, especially these days, wherein most are working from home, people tend to express themselves online, in social media, for example. And when they do that, companies should recognize that their employees have the right to express themselves online. It has nothing to do with their work for the company, for the business. So uh, the company itself should not uh, try to interfere in those situations wherein their employees are simply exercising their, don't prohibit, in short, your employees from expressing themselves when they want to do so online. Uh, there may be, or it is possible for us to impose reasonable restrictions, especially if expressions of sentiments could already lead to negative repercussions also on the business or on the organization. But we should make it clear as to where to draw the line. We should not prohibit all types of behavior wherein people simply want to express themselves. Similarly, when we're talking about the right to privacy and things that people do online, so many people right now, employees, have their own social media accounts. So what they do in their personal accounts should primarily be their business. As an organization, as a company, we have no right to interfere in what, or to know what our employees are doing in their personal private accounts. It would be a different matter if uh, our employees are actually using official company social media accounts, for instance. So in that particular situation, yes, a company can put up all these regulations, restrictions as to what employees can post using the company account, but not when they're using their own personal accounts. And similar to expressions of the freedom of expression and exercising that online, the company should know when it is proper or acceptable to actually uh, at least have something to say insofar as what its employees, what its personnel are doing in their personal accounts. If it has no business, or if it cannot invoke any legitimate reason for prying into their personal lives, then it should not do so. One last example I'd like to give would be uh, in relation to equipment or tools that employees or personnel use in the performance of their work. If employees are using their computers issued actually by the company, uh, let's say today during work from home arrangements or in work from home setups, then a company has there is a reasonable, or it is rational or reasonable actually for the company to exercise control over that particular device, meaning it can look into what is being stored in that particular device, what it is being used for, and so on and so forth, because that device is property of the company. And it's best practice that the company just informs its employees beforehand, before issuing or at the time it issues those computers, those devices. It tells them that You should only use this for work-related purposes, for office-related purposes. You are not to use this for personal uh, purposes, personal reasons, and that if you want to do it in that manner, you can also be quite blunt and say that the company reserves the right to inspect this device and so on and so forth. It would be a different matter if an employee is using his or her personal device or personal computer while performing work for the company, for the business, for the organization, especially in the situation that we have right now, where many people are working from home, and if your company did not issue any computer, any device in favor of that employee in order for him or her to perform his or her work, uh, then you need to be sensitive about that. You need to acknowledge now that that device is the property of your employee, of that individual, and then you have no business in trying to inspect what is in there. You have to now have to respect the privacy of that employee, of that individual. So there. Second to the last would be there may be also situations wherein as a company, as an organization, we are not actually the ones directly violating the rights of these individuals. In that story about Facebook and its Cambridge Analytica fiasco, the entity or entities actually that did the most damage, the most harm to the people, to the users, was not actually Facebook. It was these third parties, these companies, which used the Facebook platform to collect all this information from Facebook users. That being said, Facebook still had an obligation to make sure that that did not happen, or at least if that happened, that there be consequences, uh, that those third parties rather be made to pay for if they violated any of its policies. And most important of all, there has to be those policies that actually should have prevented that company or those companies from doing what they did. So this is what we mean by even if as a company we ourselves do not commit the violations, we should have mechanisms in place to make sure these violations being committed by other entities uh, are not do not transpire or do not happen. And if they do happen, there should be proper protocols, proper processes that can be availed of, especially by our users, by our clients, by our customers, so that those third parties can be held accountable. And then finally, we have this. As entities, there may be situations wherein there will be disputes between us and uh, individuals. For instance, again, our employees. Let's say it's a labor case, and if we cannot settle it amicably, it's going to be submitted before a labor arbiter. It could reach the NLRC or even the courts. In those types of situations, we have to let the case run its course. We have to acknowledge uh, and let due process uh, happen. We cannot resort to extralegal or illegal means in order to secure rulings or decisions in our favor. So that's what we mean by this. Because in that particular situation, the government sitting as a tribunal, as a judge, is also living or trying at least to live up to its own obligation of upholding the right of the laborers, the employees, to due process. They also have the right to a fair trial. They also have the right to an independent and competent tribunal, which the NLRC or the labor arbiter or the court should be uh, trying to uphold by being independent, by being competent in making its decisions. Now, if we as a company, as a business, try to, let's say, bribe a judge or a labor arbiter, then we are undermining actually the efforts of the government to uphold its own obligations, human rights obligations rather. So we should not also do that. So for the first four examples that I gave, it was more of obligations or duties that are expected uh, from the companies themselves, from businesses, in terms of upholding, respecting human rights. But in this fourth one, it's actually not allowing oneself to prevent the government from upholding its own human rights obligations. So there, I'm going to end it here. And if you have any questions, you can simply relay them to the organizers of this particular set of sessions. Thank you.